accused person. And when that person becomes an accused person, they are arraigned before court. They are taken before court. And the charges that have been brought against them, right now we still have a situation where, because a decision has not been made, we have a decision that was made by the Constitutional Court, but this matter is pending appeal at the Court of Appeal. And the decision of the Constitutional Court with respect to who has the power to prosecute was stayed by the Court of Appeal. So that's the reason why charges still come from the police station. They make a decision to charge an accused person. So until the Court of Appeal makes a decision, it looks to me clearly that this is a matter that will go all the way to the Supreme Court. So an accused person is then arraigned before court with the charges that have been brought against them. And then they take plea. The charge is processed at the court registry. It is given a court file number, and then the accused person is arraigned before the court. Arraigned is to be presented before a court of law. So it is the processing and the allocation of a hearing of a case file number is done in the court registry, the criminal court registry, and then the accused person is then appears before a magistrate in an open court. And then the charges are read out, charges are read out to the accused person, and the accused person pleads to the charges. Now, if the accused person pleads guilty to the charge, then the prosecutor, the court will enter a plea of guilty. And then the prosecutor is the one who will then read the facts of the case to the accused person. The facts of the case. The facts of the case, not particulars, but the facts of the case are read out by the prosecutor. Then after the prosecutor has read out the facts of the case, the court is going to ask the accused person if those facts are correct. The facts of the case are a summary of the key elements of the charge that has been brought against the accused person. So when the court then asks the accused person if the facts are correct, and if the accused person says it is true, the facts are correct, and admits the facts as read out to the accused, then the court proceeds to convict the accused person on his own plea of guilty. Convict the accused person on his own plea of guilty. So remember, when the accused person pleads guilty to the charge, when the charge is read, the magistrate does not convict the accused at that stage. At that stage, the facts are read out to the accused person first, and after the accused person admits the facts, then the court proceeds to convict the accused person on their own plea of guilty. So that is when a conviction is entered. After the conviction is entered, the prosecutor is the one who will address the court first and will be informing the court about the accused person's antecedents, past, if the accused person has maybe committed an offense or something like that. Usually, at that stage, if accused persons plead guilty, more often than not, they don't have the accused person's record. And that is why you hear the prosecutor informing the court that they treat the accused person as a first offender. In other words, they don't have the accused person's record or records, but then they're asking the court to treat the accused person as a first offender. So if that is and then normally the prosecutor, if they wish to, will then perhaps address the court about the effect that offense has on either the complainant or even the community or the general society at large. Then after that, the court will ask the accused person to mitigate. The court will ask the accused person to mitigate, and the accused person will offer their mitigation. And after their mitigation, the court may ask for a report from the victim that is known as the victim impact statement. It is not a very common practice in these developing countries, ours being one of them, but in the developed countries it's a very common practice where the victim always addresses the court. And when we're talking about victim here, we're talking about the person who is the one that has been injured by the action of the accused person. So the victim impact statement is given if the court asks for it, then the victim comes to address the court. So it could be before mitigation, it could be after mitigation, it doesn't make a difference. It just depends on how the court proceeds. And once that is done, then the court may also at the same time, after getting the victim impact statement, the court may ask for what is known as a probation report. It's called a social report or a probation report. So the social report is given, the court asks the probation for it. Normally in cases where accused persons plead guilty to the charge in the first instance, the court will ask for probation report, just to get information with respect to this person who is before the court. And then after that, then the court will record what is known as a pre-sentence address. Pre-sentence address, where the court will take into consideration the information given by the prosecutor, the information that the court gets from the accused person during mitigation, and the information that is given by the victim, if there was a victim impact statement at all, and also the court will take into consideration the probation report. So the court will take into consideration all of that during the pre-sentence address, where it analyzes all of that, and then it reaches a conclusion on what kind of sentence it's going to give, and proceed to sentence the accused person. So the court sentences the accused person, and that's it. The court becomes, after that, of course, the accused person is informed of their right of appeal of 14 days, and the accused person, the court becomes functus with respect to that accused person. If there are more than if it's more than one accused person in the file, it is only with respect to that accused. The court will proceed on with the others if the others pleaded not guilty. Up to that point, are we together? Okay, so then now let's take a case where the accused persons plead not guilty. So we are going to a trial. We're going to a trial. So the accused persons, the charges are read out to the accused, or the accused persons if there are more than one, and then they deny the charge, or the charges. So the court proceeds to give a hearing date. And the hearing date normally will be based on the court record, on the court diary. So the court is usually, as a matter of practice, the court will look at its diary and give a date. Of course, if the accused person is represented, the defense counsel will be given a suggestion as to when a date will be available, and then the prosecution and the defense will have an input and inform the court on what date is convenient. But the court is the one that gives direction. Of course, sometimes the prosecution may want an early date based on the fact that it needs some witnesses to testify early. And then after that, after hearing date is set, that is usually when the court considers bail. The court will automatically consider bail, and then the bail terms are set. So a hearing date is set first, and then bail terms are set. After that, then the matter comes now for formal hearing. And then on the hearing date, of course, it depends on whether the parties, that is the prosecution and the defense, want to give an opening address. If they want to give an opening address, then they will address the court before the matter starts. And then the prosecution's case commences. The prosecution calls its witnesses, starting obviously with the complainant, and then all the other witnesses who go through the process of examination in chief, cross-examination, and re-examination. And then that goes on with all the witnesses until the prosecution has exhausted all its witnesses, and then the prosecution informs the court that it's closed its case. And then the court will then direct the parties to give submissions if they want to, if they are able to give, or if they intend to give submissions. And once they've given submissions, normally what will happen as a matter of practice is that because these days submissions are written, the court will proceed to give a date for ruling, and then the parties will will proceed to compile their submissions in writing, and then the same is just sent to court. And as a matter of practice, a date is set, a mentioned date is set just to confirm that the submissions have been submitted, they have been brought to the court, and they're part of the court record. And then the court will give a ruling. After the closure of the prosecution's case, the court gives a ruling, not a judgment, a ruling. And if the court finds that the accused person, that the prosecution has failed to establish a case against the accused person, then the court will find the accused person has no case to answer and acquit the accused person under Section 210 of the Criminal Procedure Code. If the court, however, finds that the prosecution has established a case against the accused person, then the court will find the accused person has a case to answer, and the accused person will be put on his or her defense. And when the accused person is put on their defense under Section 211, which is very important for you to remember, the court will then explain to the accused person the process that is used for the accused person to proceed on with their defense. And under that section, the accused person will be explained to that they have 3 options to choose from if they are going to give their defense. For some of you who appeared before some of the panels and the panel myself, I'm sure you probably will ask a question related to why is it, or who in the litigation field, any litigation, who is it, is the only person who does not have to give evidence under oath. Who does not have to give evidence under oath? Yes, only the accused person, because again, the accused person has those protected rights that are set out in the Constitution, and the accused person has, of course, the right to silence, the right not to self-incriminate, and all those protections that are given to an accused person. And that is the reason why you cannot obligate the accused person to take oath and give evidence under oath. So the accused person has 3 options under 211, and then they pick one of the options. The defense case proceeds, similar to the prosecution case. And after they've called all their witnesses, the defense now, then the defense indicates to the court that it closes its case. And once that is done, the court will then ask the parties if they are going to make submissions for, whether to convict. Remember, the other submissions are at the no case to answer stage, are whether to find the accused person, if the accused person has a case to answer or not. At this stage, after the closure of the defense case, the submissions are as to whether the prosecution has proved the case against the accused person beyond all reasonable doubt or not. And then the court retires to write a what? A what? Judgment. Sorry? Can't hear you. I'm not hearing you. Somebody saying something. Who wants to try? If it's a question of trial. The court retires to write what? Remember, at the other stage it is ruling. So at this stage it would be? Yes, of course. So at that stage the court gives a judgment, not a ruling, a judgment. And remember, this is important for you to remember now that you're facing your exam, your final exam, because you might be confronted with a case, facts which show that the court gave a ruling, and then you're supposed to file maybe an appeal, and you're expected to do a memo or something like that. So you're supposed to indicate what it is that and the effect of that decision on the basis of the appeal that you are going to prepare, the memorandum of appeal that you're going to prepare for appeal purposes. So after judgment is delivered by the court delivers judgment under Section 215 of the Criminal Procedure Code. I don't want you to bother with provisions at this stage. At the stage where you're now headed, you just need to know the process. If you start quoting sections and so on, you will have problems. Sometimes you may do that. You quote the wrong section and you lose marks because of that. So just know what the process is. And then after judgment is delivered, then the first person to address the court after the delivery of the judgment, if the court finds that the accused person, the prosecution has proved the charge against the accused person, then the accused person is convicted. If it finds that the prosecution has failed to prove the charge against the accused person beyond all reasonable doubt, then the accused person is acquitted, and that ends there. That ends there. The court will only make orders with respect to bail, maybe release of exhibits. That's it. But if the court finds that the prosecution has proved the charge against an accused person, then the court proceeds on with the sentencing process. And that is where the court will take, again, the same process that we talked about. When an accused person pleads guilty to the charge is followed when an accused person is found guilty after a judgment is read. So the whole process goes on all the way up to sentencing. Sentencing is a topic on its own. We're going to do it on its own. So up to that point, is there any question? I believe I've simply repeated basically what, in summary form, what the trial process is.